If you hold a green card, if you are waiting on a visa, if you overstayed your authorized period even by 1 day, or if you are a naturalized United States citizen who was born in another country. Today's video is one you cannot afford to skip. Everything inside the Department of Homeland Security just changed at the top, and the ripple effects are already reaching airports, courtrooms, immigration offices, and neighborhoods across America. On March 23, 2026, the United States Senate voted 54 to 45 to confirm Senator Markwayne Mullin, a Republican from Oklahoma, as the 9th Secretary of the Department of Homeland Security. He replaces Kristi Noem, who was fired by President Donald Trump on March 5, 2026, making her the first cabinet secretary to be removed during Trump's second term. Mullin was sworn in on March 24, 2026, and he is already making changes that directly affect millions of immigrants, green card holders, and even some U.S. citizens. So in today's video, we are going to break down exactly who Markwayne Mullin is, why Kristi Noem was fired, what specific policy changes have already been announced, what this means for green card holders, what this means for visa overstays, what this means for naturalized citizens, what this means for people with pending cases, and most importantly, the exact steps you need to take right now to protect yourself and your family. Stay with me to the very end, because I'm going to give you a complete action plan. Let's get into it. Before we can understand where we are going, we need to understand what went wrong. Kristi Noem's tenure as DHS Secretary was one of the most controversial in the department's history, and the reasons for her firing are directly relevant to what comes next. The most devastating issue was the fatal shootings. During aggressive immigration enforcement operations that Noem championed, 2 U.S. citizens were killed by federal officers. Alex Preddy, an intensive care nurse in Minneapolis, was shot while trying to help a woman knocked down by immigration officers. Renee Good, a poet and mother of 3, was shot in her car. These deaths triggered nationwide protests and intense scrutiny of DHS tactics. Then there was the 170-citizen detention scandal. A ProPublica investigation documented at least 170 cases of U.S. citizens, American citizens, who were detained by federal immigration officers under Noem's watch. Despite this documented evidence, Noem publicly denied that any U.S. citizens had been detained, a claim that was widely fact-checked and found to be false. On top of that, Noem implemented a contract review policy requiring her personal approval for any DHS contract exceeding $100,000. This created massive backlogs and was blamed for delaying disaster relief funding to states hit by natural disasters, causing bipartisan anger in Congress. There was also the issue of enforcement tactics under controversial Border Patrol official Greg Bovino, whose masked agents conducted sweeps through communities in Los Angeles, Chicago, and Minneapolis, breaking into homes without judicial warrants in at least 28 documented cases according to Senator Richard Blumenthal. And during Noem's tenure, 53 people died in ICE and CBP custody, a record number that drew demands for documents and investigations from congressional Democrats. All of this combined made Noem's position untenable. On March 5, 2026, Trump fired her and nominated Mullin the same day. Noem was reassigned to a special envoy role. Here is why this matters to you. The new secretary inherits all of these controversies, and the policies he implements in the next 90 days will directly shape how immigration enforcement operates for the rest of 2026 and beyond. Markwayne Mullin is a first-term Republican senator from Oklahoma. Before politics, he was a businessman who ran a plumbing company. He served in the U.S. House of Representatives before winning his Senate seat. During his confirmation hearing on March 18, 2026, Mullin made several significant commitments that tell us where immigration policy is heading. He told the Senate Homeland Security and Governmental Affairs Committee, and I quote, "I hope that I'm not on the news 6 months from now every day. I hope DHS is just able to be laser-focused on doing their job, and it isn't controversial about taking care of the homeland." He added, "I hope people have confidence in our agency again, and I'm going to work every day to restore that." This tone is dramatically different from Noam's combative approach. But make no mistake, Mullen has not signaled any retreat from the Trump administration's core deportation agenda. White House spokesperson Abigail Jackson stated clearly, "Nobody is changing this administration's immigration enforcement agenda. If you're in the country illegally, you're subject to deportation." The difference is in how enforcement will be carried out, not whether it will happen, and that distinction matters enormously for everyone watching this video. His confirmation was not without controversy. During the hearing, Senator Rand Paul of Kentucky criticized Mullen for once challenging a witness to a fight during a 2023 congressional hearing, questioning his temperament. Paul asked him to explain to the American public why they should trust a man with anger issues to set the proper example for ICE and Border Patrol agents. Mullen responded calmly, "I can have difference of opinions with everybody in this room, but as Secretary of Homeland, I'll be protecting everybody." Let me walk you through the specific changes that have already been implemented or announced since Mullen took office on March 24, 2026. The biggest immediate shift is the judicial warrant requirement. Mullen stated clearly during his confirmation hearing, "We will not enter a home or place of business without a judicial warrant, unless we're pursuing an individual who runs into a place of business or a house." Under Noam, ICE agents were entering homes and businesses with only administrative warrants, which are signed by immigration officials themselves, not by judges. This led to the 28 documented cases of forced home entries that Senator Blumenthal raised. What this means for you is significant. If ICE comes to your door, they now need a warrant signed by a judge. Do not open the door without seeing a judicial warrant. Know the difference. An administrative warrant has Department of Homeland Security at the top, while a judicial warrant has a court name and a judge's signature. The second major change is the rescinding of the $100,000 contract review policy. On April 2, 2026, Mullen signed a memo eliminating Noam's bottleneck. The new threshold requires only the DHS Deputy Secretary's approval for contracts above $25 million, and component leaders within DHS handle everything below that threshold. This may sound like an internal bureaucratic change, but it directly affects how quickly USCIS can process cases, how quickly FEMA can deliver disaster relief, and how efficiently the entire department operates. Mullen has also signaled a fundamental shift in how ICE operates by saying he wants ICE to function more as a transport service than a frontline enforcement unit. His exact words were, "I would love to see ICE become a transport more than the front line. If we could get back into just simply working with law enforcement, we're going to them and picking up these criminals from their jail." This signals a move away from community raids and sweeps and toward a model where ICE picks up suspects from local jails after they have been arrested by local police. If you are a green card holder or visa holder with no criminal record, the likelihood of being swept up in a random community operation should decrease under this model. However, this depends on cooperation with local law enforcement, and not all jurisdictions will participate. Mullen's team is also reviewing all immigration detention warehouse projects across the country. The mega warehouse construction program that Noam pushed is now paused pending a cost-benefit analysis. Local communities like Oakwood, Georgia, where DHS had planned to build a sprawling detention facility with no public hearings, are cautiously optimistic. The city manager of Oakwood, B.R. White, told CNN, "Until DHS ICE proves me wrong, I will work under the notion that their past behavior is an indication of their future performance. I do desire to be proven wrong." On April 6 and 7, 2026, Mullen raised the possibility of withdrawing Customs and Border Protection officers from airports in so-called sanctuary cities. This means that international travelers arriving at airports in cities like San Francisco, Chicago, or New York could potentially face severe delays or the inability to process through customs at all. This is being used as leverage to force sanctuary cities to cooperate with federal immigration enforcement. If you travel internationally and fly into a sanctuary city airport, monitor this situation very closely. Finally, Mullen is pausing plans to use DHS planes to fly migrants to other countries. This is not a halt to deportation flights entirely, but a review of the cost-effectiveness of how those flights were managed under NOAM. A DHS spokesperson clarified, "There is no plan to pause deportation flights entirely. The agency regularly charters aircraft to deport migrants, but Mullen wants a cost-benefit analysis before continuing the program as structured. If you are a lawful permanent resident, a green card holder, here is exactly what you need to know. The Trump administration's position remains that anyone in the country illegally is subject to deportation. But for green card holders specifically, several risks remain elevated, and some new ones have emerged. On the travel front, green card holders who travel internationally are encountering increased scrutiny at airports. CBP biometric entry-exit tracking has been in effect since December 26, 2025. Your face is scanned when you leave and when you return. If you have been outside the United States for more than 6 months, you may be questioned about whether you have abandoned your residency. Trips longer than 1 year without a re-entry permit can result in loss of your green card. Closely related to this is the Form I-407 pressure. Immigration attorney Sekou Clark has warned that green card holders are increasingly being pressured to sign Form I-407 at airports, which is a voluntary abandonment of your permanent resident status. Listen to me carefully. CBP officers cannot force you to sign this form. Do not sign I-407 under any circumstances without speaking to an immigration attorney first. Signing it means you voluntarily give up your green card, and it is irreversible. On the business side, effective March 1, 2026, green card holders are barred from SBA 7A and 504 loans. Any ownership stake, even 1%, by a green card holder disqualifies a business from SBA-backed financing. In fiscal year 2025, there were 358 loans approved for businesses with partial lawful permanent resident ownership. All of those would now be ineligible. If you own a business, you need to explore private lending alternatives immediately. DHS is also now checking social media accounts more aggressively. As of March 30, 2026, the State Department expanded social media vetting to 14 additional visa categories. Attorney Sekou Clark advises cleaning your social media and making sure there is nothing anti-Semitic or illicit on your accounts, because DHS is actively reviewing them. Perhaps most concerning for green card holders considering citizenship is the denaturalization push. The Trump administration has set a quota of 100 to 200 denaturalization cases per month, stripping citizenship from naturalized Americans. The Justice Department secured a denaturalization case as recently as March 26, 2026, against a convicted gun trafficker. While these cases currently target individuals who concealed crimes during their naturalization process, the expanded effort means your entire immigration history will be reviewed more carefully than ever before. Immigration attorney Sekou Clark advises that green card holders should take several immediate steps under the new DHS Secretary. Fix your taxes first, because tax issues can trigger a public charge finding or a felony investigation. Avoid long trips outside the U.S. because anything over 6 months can disrupt the continuous residency required for naturalization. Strengthen your evidence, especially if you have a marriage-based green card, by making sure your tax returns, leases, and bank accounts reflect a genuine shared life. Clean your social media thoroughly. And audit your entire case, reviewing your complete immigration history before filing for naturalization, so that any issue, any criminal history, any discrepancy can be fixed before you submit your application. If you overstayed your visa, whether by 1 day, 1 month, or 1 year, you are in the highest risk category right now. According to DHS entry-exit overstay reports, visa overstays represent one of the largest categories of undocumented immigrants in the United States. Under both NOAM and now Mullen, enforcement against overstays remains a stated priority. The numbers tell the story. ICE arrests have topped 1,100 per day on average in 2026, according to the New York Times, far higher than the rate of roughly 600 arrests per day in spring 2025. Since January 2025, ICE has arrested more than 146,000 immigrants with no charges or convictions, compared with 127,000 who did have criminal histories. This means nearly three-quarters of immigration detainees in February 2026 had no criminal convictions, according to the Transactional Records Access Clearinghouse. While Mullen has signaled a desire to focus on the worst of the worst, the data clearly shows that enforcement still sweeps up large numbers of people with no criminal record, many of whom are visa overstays. On the topic of domestic travel, since May 7, 2025, the Real ID Act is fully enforced. You need a Real ID-compliant driver's license or another acceptable form of identification to board any domestic flight. If you do not have a Real ID, TSA now offers a temporary Confirm ID for a $45 fee, valid for 10 days. However, flying domestically does not guarantee safety from immigration enforcement. ICE agents have been present at multiple airports across the country. If you are a visa overstay, your options depend on your specific circumstances. Some individuals may be eligible to adjust status through a qualifying family member. Others may be eligible for certain forms of relief, such as cancellation of removal, if they can demonstrate 10 years of continuous physical presence and exceptional hardship to a qualifying U.S. citizen or permanent resident relative. Consult an immigration attorney immediately and do not wait. If you are a United States citizen, you might think none of this affects you. You would be wrong. If you are a naturalized citizen, the denaturalization program is real. USCIS guidance sets a target of 100 to 200 referrals per month to federal courts to strip citizenship from naturalized Americans. Currently, the program targets individuals who concealed criminal activity, committed fraud during the naturalization process, or obtained citizenship through a marriage that was later found to be fraudulent. But immigration advocates warn that the expanded scope could catch people who made innocent errors on their applications years or even decades ago. The American Immigration Lawyers Association has called denaturalization unprecedented in its current scale and warns that it threatens the rights of all naturalized citizens. If you are a U.S.-born citizen with immigrant family members, the enforcement climate affects your family directly. Spouses, parents, and children who are undocumented or who have pending cases face elevated risk. The arrests of military spouses on their way to green card interviews, raised during Mullen's confirmation hearing by Senator Andy Kim, illustrate that even people actively going through the legal process can be caught up in enforcement operations. Mullen responded that if immigrants are going through the process of legally residing in the United States, the government is going to continue working with those individuals. Hold him to that promise. If you are a citizen who lives in a sanctuary city, Mullen's threat to pull CBP officers from sanctuary city airports could affect your ability to travel internationally. If CBP officers are withdrawn from your local airport, international flights may be rerouted, delayed, or canceled entirely. Monitor this situation if you live in or near San Francisco, Chicago, New York, or other sanctuary jurisdictions. And if you are a citizen who has been wrongly detained, remember that 170 U.S. citizens were detained by ICE under Noam's tenure. If you are detained and you are a U.S. citizen, clearly state your citizenship, request to speak with an attorney, and do not sign any documents. Ask for a supervisor. You have the right to a phone call. Contact the ACLU Immigrants' Rights Project at aclu.org or call the United We Dream helpline at 1-844-363-1423. There is another critical piece to this story that most people are not talking about. When Mullen was sworn in on March 24, 2026, the Department of Homeland Security was in the middle of the longest partial government shutdown in U.S. history. Nearly half of DHS workers were not getting paid. On March 26, Senate Democrats and Republicans reached a bipartisan agreement to fund most of DHS, but they excluded funding for ICE and parts of the Border Patrol. The House passed a separate bill. As of this recording, negotiations continue, and the funding status of ICE remains uncertain. On April 3, 2026, the White House issued a presidential memorandum titled, "Liberating the Department of Homeland Security from the Democrat-caused shutdown. Why does this matter to you? Because an underfunded DHS means slower processing times for everything: green card renewals, naturalization applications, employment authorization documents, asylum cases, and every other immigration benefit. USCIS already has a record backlog of 11.3 million pending cases. A prolonged shutdown makes everything worse. One of the most important developments is the bipartisan deal that Mullen explored before his confirmation. According to the New York Times, reporting on March 21, 2026, Mullen engaged in discussions that would effectively bar civil immigration enforcement actions at certain sensitive locations, including hospitals, churches, schools, and courthouses. Under the Biden administration, these were designated as protected areas. In February 2025, DHS rescinded that protection. Under Noem, there was no sensitive locations policy at all, and enforcement actions were conducted near schools, hospitals, and houses of worship. Mullen has signaled he is open to restoring some form of sensitive locations protection as part of a bipartisan deal to fund DHS. Republican Representative Brian Fitzpatrick, a former FBI agent, introduced a bill with Democratic Representative Thomas Suozzi that would mandate agents to remove their masks in most cases, require judicial warrants for criminal arrests, and effectively bar enforcement at sensitive locations. This is not yet law. But watch this space carefully. If you work at, attend, or rely on a hospital, school, or church, the outcome of this bipartisan negotiation could directly affect your safety. Now let me give you the action plan, and please pay close attention, because every single step here could make the difference between keeping your status and losing it. The first thing you need to do is know your rights. Whether you are a citizen, a green card holder, or undocumented, you have rights. You have the right to remain silent. You have the right to refuse to sign any document. You have the right to speak with an attorney. Print a Know Your Rights card from the ACLU or NILC website and carry it with you at all times. The second thing is to never sign Form I-407. If CBP officers at the airport ask you to sign this form, politely decline and ask to speak with an attorney. This form voluntarily surrenders your green card, and it is irreversible. Third, you need to limit your international travel. If you are a green card holder, keep your trips under 6 months. If you must travel for longer, obtain a re-entry permit by filing Form I-131 before you leave. If you are a visa overstay, do not travel at all until you have spoken with an attorney. Fourth, file for naturalization if you are eligible. If you have held your green card for 5 years or 3 years, if you obtained it through marriage to a U.S. citizen, file Form N-400 now. Processing times are currently 5.5 to 10 months. Becoming a citizen is the strongest protection against deportation, though the denaturalization program means you must ensure your application is accurate and complete. Fifth, fix your taxes immediately. Unfiled or incorrectly filed tax returns can trigger a public charge finding or worse. File all outstanding returns. If you have been filing married filing separately but live with your spouse, switch to married filing jointly. Your tax returns are evidence of your life in the United States. Sixth, audit and strengthen your entire immigration file. Gather every document related to your immigration history. Every receipt notice, every approval, every travel record. If you have a marriage-based green card, compile joint leases, joint bank statements, joint insurance policies, photos, and any other evidence of a genuine relationship. Seventh, clean your social media right now. As of March 30th, 2026, social media vetting has expanded to 14 additional visa categories. Review every platform: Facebook, Instagram, X, TikTok, LinkedIn, and remove anything that could be misinterpreted by an immigration officer. Eighth, monitor your case actively. Use the USCIS Case Status Online tool at egov.uscis.gov and set up email and SMS alerts. If your case has been pending beyond normal processing times, file an e-request through the USCIS website or call the USCIS Contact Center at 1-800-375-5283. If you still get no response, contact your congressional representative's office for a congressional inquiry. Ninth, prepare an emergency plan. Have your attorney's phone number saved. Have a family communication plan in case someone is detained. Have copies of important documents stored in a safe place that a trusted family member can access. And 10th, consult an immigration attorney. I say this in every video because it is the most important step. Every situation is different. An experienced immigration lawyer can review your specific case and tell you exactly where you stand and what you need to do. Find a lawyer through the American Immigration Lawyers Association at ila.org, find an attorney, or through lawhelp.org for free or low-cost legal services. Let me give you the numbers that matter. March 5, 2026 is the day Kristi Noem was fired as DHS Secretary. March 24, 2026 is the day Markwayne Mullin was sworn in as the 9th Secretary of DHS. The Senate confirmation vote was 54 to 45. At least 170 U.S. citizens were documented as having been detained by ICE under Noem. The average pace of ICE arrests in 2026 is 1,100 per day. Since January 2025, 146,000 immigrants have been arrested with no charges or convictions. The monthly target for denaturalization case referrals is 100 to 200. The USCIS backlog stands at a record 11.3 million pending cases. In fiscal year 2025, there were 358 SBA loans to LPR-owned businesses that would now be ineligible under the March Warren's 2026 ban. The USCIS contact center number is 1-800-375-5283, and the United We Dream helpline is 1-844-363-1123. The next 90 days under Secretary Mullin will be decisive. Watch the DHS funding deal because if ICE remains unfunded, enforcement operations could be affected, though essential personnel are still working. Watch the Sanctuary City Airport threat, because if Mullin follows through on withdrawing CBP from Sanctuary City airports, it would cause massive disruption to international travel and affect millions of people, citizens and non-citizens alike. Watch the sensitive locations deal because if a bipartisan agreement is reached to restore protections for schools, hospitals and churches, it would be a significant shift from the Noem era. Watch the denaturalization numbers because if the program expands beyond individuals who concealed crimes, it could affect a much broader population of naturalized citizens. And watch the April 2026 visa bulletin because EB2 and EB3 categories are current for rest of world, and F2A is current. So if your priority date is current, file now before any policy changes could close that window. Here is the bottom line. The new DHS Secretary, Markwayne Mullin, has promised a more organized, less chaotic approach to immigration enforcement. He is committed to judicial warrants, cooperation with local authorities, and restoring public confidence. But the core enforcement agenda has not changed. Deportations continue. Denaturalization continues. Visa overstay enforcement continues. The difference is in the approach, more targeted, more procedural, potentially less violent. But less chaotic does not mean less aggressive. It may simply mean more efficient. Protect yourself. Know your rights. Get your documents in order. Consult an attorney. And subscribe to this channel because I will be covering every single development as it happens. If this video helped you, hit that like button, share it with someone who needs to hear this, and drop a comment below telling me what topic you want me to cover next. I read every single comment. Stay informed, stay safe. I will see you in the next one.